A very good morning to all my dear students. Having a great morning, seeing your beautiful morning wishes made it more beautiful. Good morning, Miss Bhargavi, Sakshi, Joa, Anuj, Sanya, Balaji, Mohammad Fareed, Anuska, Nishi, Divya. I'm good, Divya. I hope you all are also doing great. Sagufta, Sunil, Nanda. Yes, Mr. Nanda R. I hope now you can hear me and the class is there on in front of you. In this chapter, Companies Act, how much direct questions will be asked by Mr. Varun Bapri. So Varun, direct questions will also be asked. One case study based questions and most likely two direct questions generally come from the chapters of Companies Act. Good morning, Ravi Ranjan, Brajesh, Amal, Surya, Shamya, Tapaswini, Dheeraj, Heetal, Akash, Monu, all of you children. And I hope you have very well revised your chapter that we started in the previous session. The first topic that we have done, the features of the company. So let us quickly move towards the presentation and let's have a small quiz understanding how well my students have revised the concept. So we have done in the last lecture about the features of the companies. Companies is separate legal entity. Two important case laws, Makara versus Northern Assurance Company Limited, were discussed. Salomon versus Salomon and Company Limited helped you to explain how the corporate veil has been defined. And then we discussed the 5 different cases where the lifting of the corporate veil can be done. So quickly answer me, is company a person different from its shareholders? We understood that company has a separate legal entity concept. So it is asking you, is the company different from its shareholders or are they one and the same thing? So let me see how well my students have revised the chapter. So give me the answer for the first point. पेज नंबर 6.4 पे पॉइंट ए एंड बी समझ नहीं आया. Okay, Miss Divya, once we'll open the presentation, once we'll open the study material, just remind me about this point. I'll explain you. Good. Sakshi says, yes, ma'am, we have revised all the lectures. Great. And true is the correct answer. That is very much correct. And those who have written, yes, it is true because the company has a separate legal entity concept, which means company is different, shareholders are different. So basically this concept tried to absorb and protect the owners from the personal liability. So when we were having ownership, sole proprietor, we were personally liable for our business. However, in case of a company, company has its own assets, own liabilities, and shareholders are different. Now, there's another example question for you in front of you. So these are the kind of case studies which the examiner can ask you. Although MCQs is not part of your CA foundation, but still a bigger study-based questions can come. Again, MCQs help you to understand and have a major clarity of the concept that you have studied. So company ABC Limited has 5 directors and all the directors met with an accident and died. Will ABC Limited company comes to an end? The option is company will come to an end, or you will say the company continues to exist as it has a perpetual succession. So what is your answer for the second one? Mr. Abdul Sheikh Bhai Wala. Good morning, child. Ashnika Gupta, false was the incorrect answer. True was the correct answer for the previous one. And Tane Jain, Satyam Juhi, Swapna Chaudhary, Anusa, Sanjay, Sakshi Bajrang, Akash, Tapaswini, Mayank has given the correct answer, all of you, for the second one. That is second B is the correct answer. Yes, Devshri, B is the correct answer. Why? Because company has a perpetual existence. People may come or go, company continues to exist. That is the difference between a company and a natural person who is in existence. Natural person will come to an end once his life is ended. The business also comes to an end when you're a sole proprietor. 2 partners doing the firm, running the firm, partners died, the firm will also come to an end. But in a company, the members or shareholders die, the company still continue to exist. And how does the company come to an end? I also told you in the previous lecture, how will the company come to an end? The company will come to an end at the time of winding up of the company when the tribunal comes and gets the company's name strike off from the registrar of companies. Okay. Now, there's another question in front of you. That is question number 3. Yes, Varun, all of your answers are visible and you're giving the correct answers. Only those who give the incorrect answer, I specifically try to take their name. Otherwise, everyone has given the correct answer. So, Sanya Khan, after this question, I'll take up your query of corporate whale theory. First of all, immediately answer me this question number 3. ABC Private Limited Company was opened by Mr. Where has it gone? By Mr. A to distribute the income that he has earned by the way of dividend and interest to evade the taxes. In your opinion, is it advisable to lift the corporate veil? Yes, the veil should be lifted. Or no, the company is different from its members and corporate veil should not be lifted. Now read the question very carefully. Try to understand what he is trying to ask you from the same and then give me a better answer along with the name of the case law, which is supporting case law, in order to give you the answer for this one. So I don't want just the answer. Sagufta, Juhi, Ranjit, all of you have quickly given me the answer. So third, A option is the correct answer. That is absolutely correct. Yes, the veil should be lifted. Can you quickly name the case law which tells you why the corporate veil should be lifted in this respective case? Yes. Mr. Nanda R is asking if all the partners have died, how the company is going to run because it depends upon humans. Very excellent question, Mr. Nanda R. So it simply tries to tell you the company has a perpetual succession. Company continues to exist. So company is being run by some human agency behind them. But even if the humans have died, the company's name still continues to exist. That is what we understood in the concept of separate legal entity. Company is different, shareholders are different. तो अगर ह्यूमंस नहीं भी हैं तो कंपनी के जो एसेट्स हैं, कंपनी की लायबिलिटीज है, कंपनी की ओनरशिप, company has entered contracts in its own name, so it still continue to exist. Company will be surviving. It may be taken over by other shareholders or it may be winded up by the tribunal. Company will not end simply because the shareholders are not. Okay. Yes, Dinshaw Manekji Pettit is the correct case law. Okay, don't worry, Miss Ashnika Gupta. You can refer to the previous lecture. It's a recorded lecture already there on the YouTube, so you can refer to that as well. Ravi Ranjan has given Daimler Company, which is absolutely incorrect. Dinshaw Manikchi Pettit is the correct answer. Anusa Nishi Garg. All of you have given the correct name. Nanda R. Anuj Segufta. All of you. Pavan Balaji. So that is the correct name. Now, what happened in this case law? Somebody who was asking, ma'am, why this case law is applicable. So in that case law, Mr. Dinshaw, when he was earning huge incomes by the way of dividends and interest. So when you have huge incomes, what do you have to pay to the government? You have to pay taxes to the government on your income. Now, in order to evade taxes means in order to avoid the taxes, what did he do? He opened 4 different companies in which he invested his entire interest and dividend income. For example, उसके पास 1 करोड़ पैसा आया, उसने 25 लाख 25 लाख 25 लाख 25 लाख करके चारों कंपनीज में पैसा इन्वेस्ट कर दिया और अपना प्रॉफिट एंड लॉस अकाउंट ब्लैंक दिखा दिया. He earned money and he invested in different companies and then took a loan from those companies. अब उन कंपनीज में प्रॉफिट दिखना था तो टैक्स लगना था, तो वहां पे भी प्रॉफिट नहीं दिखाया, वहां से लोन ले ली. So it was a circulation of money that was happening. He was only trying to avoid the taxes. Now, this is the hidden story behind the Dinshaw Banerjee Pettit case. Now, how it is related to the corporate way. So when the lawyers went and the government asked Mr. Dinshaw that what are you doing? You are evading the taxes. You're not paying the taxes. You're just creating the company. The company is known as a sham. Sham means a fake company. It's not a genuine company that you have created with your dividend and interest income. You're just trying to fool the government. You're just trying to avoid paying the taxes. So what did government say? That you are doing a wrong thing. So Mr. Dinshaw said, there's a corporate veil between me and my company. My company is different and I am different. So go hold my company. So like Mr. Nanda was mentioning, some human agency is there who is running behind the company. So in such cases, corporate veil will be lifted and humans, Mr. Dinshaw and the company were treated as one. So we did 5 respective cases in the last lecture. So if those who have missed those last lecture, it was very important. It lays down the foundation of how the company has been formed, the separate legal entity concept. You must go through that previous lecture. Those who were absent in the previous one, those I've mentioned. So you must attend that lecture, because there I've explained you how the corporate veil exists between the company and shareholders. And these are the 5 cases where the corporate veil will be lifted and the shareholders and company will be treated as one. All right. So this is how you have to apply the principle of corporate veil theory, and that is how you have to answer this one. Now, these are the questions related to today's lecture. So after doing types of the companies, we'll jump into these basic questions which are still left to be done. Now, let's quickly begin with the classes of companies. So you all know that there are different types of companies that we will be doing today. There are companies on the basis of liability. So when we did about the sole proprietorship, in a sole proprietorship, your liability is limited or unlimited? You have to answer me. Till the time I'm opening your study material, you have to tell me, in case of a sole proprietorship, is the liability of the member limited or unlimited? Answer. In a sole proprietorship case. Excellent. So why Renuka Gaurav? So you should have attended it, and now you can refer to the previous one. Vipin, Dheeraj, Hetal, Anusa, Satyam, Ranjit, Juhi, Deepak Bhai, Sugufta, all of you are correct. Unlimited liability. I don't know why Anusa you are saying limited. It's unlimited because you are the sole proprietor. You have all the things of doing your business on your own. So therefore, it is an unlimited liability in case of a sole proprietor. And what did we discuss in case of a company? The broader categories on the basis of liability. Today, we are going to discuss that the companies are divided on the basis of liability that they have. So we have understood that the shareholder is the co-owner of the company, but the assets of the companies are different. So now when your assets are different, I am the shareholder, I am different. I have created that ABC Choco Private Limited company. That ABC Choco Private Limited will meet its all debts and liabilities on its own. I am a shareholder. I have my own responsibilities towards the company. Because many people are investing in the company. Na? So company has its own brand name. It has its own structure. So now today we are going to understand the first category of the types of companies on the basis of liability. So there are 3 companies on the basis of liability: limited by shares, limited by guarantee, and the unlimited companies. As you were having a sole proprietor unlimited liability, similarly we have an unlimited company as well. So unlimited company is the easiest one. You all know the company is not having any limit on the liabilities. If the liability of the member ceases when he ceases to be a member, only till the time you continue to be a member, your liability remains unlimited. So let us start with the first category, that is company limited by shares. Now I have given you again a hint about company limited by shares when we were discussing the features of the company, and we discussed this point of limited liability. याद है आपको? हमने ये point discuss करा था previous lecture में, that the company has a limited liability and the liability is limited by shares or limited by guarantee. At that time, I told you, in case of a company limited by shares, how their liability is limited. So anyone can tell me, if I have taken the shares of rupees 20 each in a company, and I am a part of a company limited by share, I am a shareholder, Mr. A, and I've already paid up rupees 18 per share. Now, what is my liability for which I can be called upon in case of the winding up of the time of the company or any time during the lifetime, whenever the liability. Now, liability of the company is suppose 1 lakh rupees. मैंने आपको previous class में इसका example कराया था. Any amount unpaid on the shares held by them will be your liability. So there are rupees 20 per share, and let's assume the shares are rupees 1000. So 20,000 shares was the value. I have paid 18. So 18,000 rupees I have already paid to the company. Now, how much amount of liability I am liable to pay? Liability of the company is rupees 1 lakh. How much is the money rupees per share pending? Excellent. Rupees 2 per share is the money which is pending to be paid by this shareholder, and 1000 other shares. So now Mr. A can only be called upon to pay the liability of rupees 2000 rupees. Even if the liability of a company is 1 lakh, I as a shareholder, Mr. A, my liability is limited by shares. Only the amount left unpaid on the shares is rupees 2. So my liability will only be rupees 2000 rupees. Let me see if all my students have answered it correctly. Excellent. Very good. All of you have answered it correctly. I don't know 360 कैसे आया तपस्विनी? Only 2018. Why? What are you doing? Yes, Prince. It will be the unpaid amount. Rupees 2 per share is the correct answer. All of you have given the correct answer. It means, so this first paragraph is clear to all of you, company limited by shares. So it means meeting the debts of the company will only be contributing to the extent of the amount unpaid of the shares. बस इतना ही learn करना है इसमें learn क्या करना है? सिर्फ दो लाइन. एक तो if the company is limited by shares, your liability is the amount unpaid on the shares. Second paragraph में again he has written the same line. For meeting the debts of the company, मतलब company की liability meet करने के लिए shareholder will only pay the amount unpaid of the shares. So both the things are same. His separate property cannot be called to meet the company's debts. अब मैं ये नहीं कह सकती 2,000 rupees हमने पे कर दी है तो out of 1 lakh 98,000 rupees you have to sell off the Mr. A's assets. No, you are not required to sell off Mr. A's assets. His property is separate, company's property is separate. Both of them have, company has a separate assets, shareholder has separate assets. His separate property cannot be called to meet the company's debt. Why? Because shareholder is a co-owner of the company. He is not the co-owner of company's assets. Ownership is because of legal person. Ownership of the company's assets is with the company because the company is a legal person. Some natural, artificial person has come into existence. Extent of rights and duties of a shareholder as co-owner is just measured by his shareholder. So रिलायंस में मैंने इन्वेस्ट करा, मैं 2% की शेयर होल्डर हूं, तो मेरे 2% शेयर है उस कंपनी. मैं ओनर नहीं बन जाऊंगी रिलायंस के. आई एम जस्ट हैविंग 2% शेयर होल्डिंग. The company's assets are owned by the company itself. All right. Now, for example, rupees 2 per share I am holding. I have paid rupees 1 per share. Rupees 1 is pending. So whenever the liability will arise, Harleen ma'am can only be called to pay the unpaid amount of the shares. That's it. That is what my liability is to respect of that company. And what is company? No, you don't have to learn these sections. Those who are asking, sections are not mandatory. Leave the sections, but you should be very much sharp about the concept that you know. अब गारंटी का मतलब होता है किसी को गारंटी दे देना कि भाई अगर तुम्हारा कल को नुकसान होता है तो मैं 10,000 रुपए दूंगा. या फिर किसी ने कहा अगर तुम्हारी कल को कोई लाइबिलिटी आती है तो मैं 15,000 रुपए दूंगा. या फिर मैं 2,000 की, कितने भी अमाउंट की आप गारंटी दे सकते हो. आप मेमोरेंडम ऑफ एसोसिएशन आपका डिफाइन करेगा कितनी अमाउंट ऑफ गारंटी आपने लाइबिलिटी अंडरटेकन करी. So both these liabilities of limited by shares and limited by guarantee is mentioned in the memorandum of association. So जहां पे आपका study material दिया हुआ है यहाँ पे भी लिख लो MOA. MOA defines the liability in case of limited by shares and MOA defines the liability limited by guarantee also. So where this liability is defined, where it is written company ABC Limited आपने बनाई, उसके MOA में आप लिख दोगे इतनी liability Mr. A की pending, जैसे कि हमने अभी 2,000 rupees workout करा. Similarly, in case of a company limited by guarantee, for example, A says, I will pay you rupees 10,000. B has given the guarantee of 15,000. C has given the guarantee of 25,000. So now all these amounts of the liability given as guarantee will be mentioned in the MOA of the company, not in the AOA of the company. And what is MOA and what is AOA? Part of your third lecture when we discuss about memorandum and articles of association. अभी के लिए MOA, memorandum of association, is a very important document of the company. तो इन दोनों की liabilities यहाँ पे study में लिख लेना. MOA में mention है यहाँ पे भी और limited by guarantee भी MOA में. Now suppose the liability of the company is rupees 1 lakh. How much amount can I ask Mr. A to pay? 10,000 rupees. How much B will pay? 15,000 rupees. So 25,000 has been paid. 75 is still pending. I will call Mr. C. You also pay your liability. How much Mr. C will pay? Will Mr. C have to pay the balance 75,000? No, ma'am. C will also pay rupees 25,000. जितनी guarantee दी है उतना ही pay करेंगे. Guarantee का मतलब ही है. I have guaranteed for this much amount. I will not pay beyond that because my liability is limited. Here, the personal assets are not liable for the company's debts. So 50,000 liability has been paid by all these members. Balance 50,000, you dispose of the company's assets or whatever you want to do, you pay out to the company's assets. Members are not going to pay you beyond this. And second point, company limited by guarantee will be contributing only in the case of winding up of the company. Now listen very carefully. In case of company limited by shares, when this liability of 1 lakh was arising and Mr. A was paying 2,000 rupees, Any time the shareholder can be asked to pay for this liability during the lifetime of the company. However, in case of company limited by guarantee, you can members, ABC, were the members who have given the guarantee of 10, 15 and 25,000, they can be required to pay off the liability only at the time of winding up of the company. हिंदी में जब कंपनी को बंद किया जा रहा है, खत्म किया जा रहा है, तभी मैं इन शेयर होल्डर से पूछ सकता हूं कि अब आप अपनी लाइबिलिटी पे कीजिए, अगर मेरी लाइबिलिटी बुक्स में उस डेट को आ रही तो इतनी ही लाइबिलिटी ये लोग पे करेंगे, इन्होंने इतने अमाउंट की गारंटी दी. However, in company limited by shares, any time during the lifetime of the company or winding up, both the times I can ask the shareholders to pay their liability. This is the major difference between company limited by shares. Their liability, they have to pay during the lifetime or during the winding up. Company limited by guarantee, only during the winding up of the company, they will have to pay the liability that they have guaranteed to pay. Clear हो गया? So liability is guaranteed up to a stipulated amount. अभी हमने डिस्कस करा stipulated amount means fixed amount. Stipulated amount का meaning लिख लेना. Stipulated amount means the fixed amount. If any person fails to pay the amount, Ms. Hetal, definitely the company is going to take an action. Company limited by guarantee. If it is in the winding up, you have guaranteed to pay this much amount, then you have to pay. Any contraventions, you go to CA enter, you will understand how much penalty is being charged. यस मिस्टर मयंक, कॉन्ट्रैक्ट में भी गारंटी होती है, तो उसी तरह की गारंटी. गारंटी का मतलब क्या होता है कि फिक्स्ड अमाउंट है, आप इतना पे करेंगे ही करेंगे. आई होप मिस साक्षी कुमारी, मैंने अभी हिंदी में भी समझाया, आपको अब समझ आ गया होगा. सो बोथ द लैंग्वेजेस आई हैव टू टेक केयर ऑफ बोथ द स्टूडेंट्स. चिल्ड्रन प्लीज डोंट एक्सपेक्ट मी टू टेक द एंटायर लेक्चर इन हिंदी. मैं जहां पे आपको नहीं समझ आता पूछ दिया करो, मैं आपको हिंदी में भी समझाता. मिस रुचिका कह रही है मैम वाइंडिंग अप का मतलब क्या होता है? वाइंडिंग अप मींस कंपनी क्लोज हो रही है. जब कंपनी बंद हो रही है, वाइंड अप हो रही है, क्लोजर कर रहे हैं, हम सारे एसेट्स सेल्ड ऑफ करके लायबिलिटीज पे कर रहे हैं, उस टाइम पे कंपनी लिमिटेड बाय गारंटी शेयर होल्डर्स को बोलेगी भी आपने जो गारंटी दी थी, अब आप कंपनी की लायबिलिटी में पे ऑफ कीजिए. Assets are of shareholders are different and assets of the company are different, Mr. Sheikh Bashir. Now, pay attention very much, all of you. Common feature. Both the companies have a common feature. Company limited by guarantee and share capital. Both have the legal personality and both have limited liability. Is that clear? Do you agree to this thing? Both have the legal personality, means both of them have separate legal entity concept and both have limited liability. In the latter case, latter means किसकी बात कर रहा है ये? Company limited by shares. यहाँ लिख लेना. In case of company limited by shares, liability is limited on the amount remaining unpaid on the share. However, on the case of guarantee, you have to pay the guarantee. And where it is, both of the liabilities is stated in the MOA. So these are the common features. Number one common feature is both of them have separate legal entity and their liability is limited. One's liability is limited on the unpaid shares and the other's liability is limited for the stipulated amount. And what is the second common feature? Both their liability is mentioned in the memorandum of association. इतना क्लियर हो गया सबको? दोनों कॉमन फीचर्स, एवरीवन इज क्लियर अबाउट दैट? Miss Khushi, you don't have to go into this much detail that how much the shares have been guaranteed. So whatever amount that have guaranteed to pay, that is the amount of guarantee. मैंने कंपनी का लिमिटेड, yes, that is correct. Tribunal means the body which has been constituted, National Company Law Tribunal, which comes into the role for winding up of the company. Mr. Nanda, tribunal has to take care of all the cases related to the companies. Okay, National Company Law Tribunal. Okay, very good. All of you have written yes. So here, यहाँ पर 100% clear हो गया सबको. And please restrict yourself to the information that is given in the study material. Don't try to go beyond it. सीए इंटर समुंदर है कंपनीज एक्ट का, वहां पे आपने हर चीज डिटेल में पढ़नी. अभी बस जितना दिया है उतना ही पढ़ लो, बहुत है. इससे बाहर जाओगे तो कंफ्यूज हो जाओ. सो कॉमन फीचर सबको समझ आ गया हमें? वी हैव अंडरस्टूड कंपनी लिमिटेड बाय शेयर्स एंड गारंटीज का. यस मिस दिव्या, उतनी ही लायबिलिटी आपको पे करनी पड़ेगी जितने की आपने गारंटी दी है. एब्सोल्युटली करेक्ट. Now, what is the difference between these companies? Here you have to pay attention. In the former case, again, what is the former case? Here he has given the former. Former means जो पहले नाम लिया guarantee company. Latter means company limited by shares is the latter company, second company. So here, former company के आगे आप लिख लेना company limited by guarantee. will be asked to discharge their liability only after the commencement of winding up and subject to certain conditions. So only after you have started the process of closing the company, that time the members will be asked to pay off the liability. But in case of latter means company limited by shares, anytime during the lifetime of the company or during its fund. So quickly we can write down the points of differences between company limited by shares can be asked to pay liability anytime. ये लिख लेना अपने स्टडी मटेरियल में शायद शॉर्ट नोट में, ड्यूरिंग lifetime of the company और during winding up. जब भी उनका मन करे वो तब बोल सकते हैं, वाइंडिंग अप में भी बोल सकते हैं. हाँ, अगर आपने पे कर दिए अमाउंट अनपेड ऑन द शेयर्स ड्यूरिंग लाइफ टाइम, देन यू हैव नो लाइबिलिटी लेफ्ट. It's obviously it's only when the liability is still left. Okay. Company limited by guarantee asked to be paid. आप बताओ. Only at the time of winding up. Excellent. Write it down quickly. इसके बाद फिर important case law और है. Is that clear? All right. So it is clear from the definition that the guarantee company, now this is very, very important. Now this paragraph that we're going to discuss, that is related to Narendra Kumar Agarwal versus Saroj Malu case. Now children, guarantee company does not raise its initial working funds from its members. Iska matlab kya? Suppose, let's take the names of your students. Suppose the Paswini, Narendra and Pawan, they form the company. So there is Mr. Narendra Kushwaha in my class, the Paswini in my class, and Mr. Pawan. They're thinking to form a company. So 3 members, they are thinking to form a private limited company. So minimum 2 are required. 3 members, they're forming a private limited company. So children, what do they need to contribute? They need to contribute certain capital to invest the company, to start off the company. Absolutely correct. That is how their initial working funds will come. They are starting up a company limited by shares. Once they have incorporated the company, they have invested the capital, the company got registered, then they will take the shares in the company. Till the time they have not formed the company, they're just the promoters. And then they sign the memorandum, they become subscribers. Section 9 में detail में समझेंगे, अभी मत जाओ उसके अंदर. Now what these 3 people have done, stipulated Mr. Sheikh Bashir, stipulated means the fixed amount. You have fixed certain amount that you're going to pay at the time of winding up of the company. Is that clear? Okay. So don't worry, Satyam. We'll take your name in another exam. So these 3 people are contributing towards the capital and starting of the company limited by shares. Now, Mr. Sheikh Bashir, Anuj Kumar and Satyam Kumar, they have decided to open up a company limited by guarantee. So for opening any company limited by guarantee, they don't have to invest capital. Why? Because children, please write a small note over here. Company limited by guarantee are kind of a charitable kind of organization. Charitable kind of organizations generally, not always. They can be company limited by guarantee, which are limited by shares also. Generally, the company limited by guarantee is a charitable kind of organization. So your initial working capital means जो आपकी capital है वो कहाँ से raise होती है? Initial working capital is raised from donations, endowment fees, all these kind of charges paid by people. So people are contributing, making a payment for you. So no working funds are needed. You get your working funds from the donations, fees, and charges. This is how a company limited by guarantee generally functions. So charitable organizations जो होती हैं, उनकी company limited by guarantee होती है most of the cases, where you get the donations from the people, you do a specific work for a particular kind of society, and then whenever the liability arises, members have given a guarantee up till certain amount, and the liability is met from that particular amount. Now, what happened in the case of Narendra Kumar? It says that Supreme Court said that the rights of a guarantee company to refuse to accept the transfer by a member of his interest is on a different footing than a company limited by shares. So company limited by guarantee is different from a company limited by shares. If a company is limited by guarantee, that time liability arises at the time of winding up. You only have to pay the fixed amount. Company limited by shares, anytime during the lifetime or during the winding up, and the liability is the amount unpaid on the shares. So both of them are different. So it tells you that the membership of a guarantee company may carry privileges from them of the ordinary shareholders. Now, this is something which I want you to understand. What is this privilege? Say, for example, there is a company which is limited by shares also, and the company is limited by guarantee also. So there's a company limited by guarantee in which you have taken up the shares also. So there is a company limited by guarantee, which is limited by shares also means you have taken up the shares in that company. Now, why company limited by guarantee has a advantage? Because whenever the liability will arise, first the shareholders will be asked to pay their amount. First, the shareholders will be asked to pay their amount. Then, if any balance is left, the members who have given the guarantee will be invited to pay the amount. That is the privilege that has been given to the membership of guarantee company. So the company which is limited by shares as well as limited by guarantee, whenever the liability, say for example, again, there is a liability of 1 lakh rupees. So who will pay the liability first? That Mr. A who was having a shares, he will pay his 2,000 rupees first. Now again, 98,000 rupees balance is left. Now Mr. A, B and C, 10,000, 15,000, 25,000 guaranteed amount will be paid by all the members. So first liability will be of the shareholders, and then the liability which has been given to guarantee will be required to be. And what is the second privilege that has been given to the guarantee members? That their liability arises only at the time of winding up and not during the lifetime of the company. Do we have to learn the name of case law? No, it is not required. It was just because study has mentioned it. So you should have an understanding what it actually means. Generally, the examiner is going to ask you the difference between company limited by shares or limited by guarantee, or he can give you a question based on the types of companies on the basis of liability. So all these kind of points, you have to make short notes, whatever we have discussed right now, and you have to learn all the points. Name of the case law is not mandatory. Samajh aa gaya. An unlimited company is very different company. It is same like your partnership firm and the sole proprietor, the liability is unlimited. So each member's liability extend to whole of the company's debts and liabilities. But he will be entitled to claim contribution from other members. So if I have paid whole of the liabilities, I can claim it from other members also. In case the company has share capital, articles will state the amount of the share capital. So where is the liability of unlimited company mentioned? In case of unlimited company, their liability is mentioned in the articles of association. Where is their liability mentioned? Their liability is mentioned in the articles of association. Okay. As long as the company is a going concern, the liability is only limited, which can be enforced by the company. Creditors can institute proceedings for the winding up. तो अगर creditors को लगता है कि हमारा पैसा नहीं मिल रहा है, तो वो winding up के लिए proceedings initiate कर सकते हैं. And official liquidators will call. What is the meaning of winding up? Winding up means the company is going into closure. And when the company goes into closure, children, official liquidator is appointed. Remember when I told you when an individual becomes insolvent, official assignee is appointed, and when a company becomes insolvent or the company is going into winding up, official liquidator is appointed. So liquidator is a person who will take care of all the assets and liabilities of the company. He will sell off all the assets of the company and in order to pay off the liabilities. So the official liquidator will tell the members to make the contribution towards the liabilities, which is unlimited. Unlimited का meaning क्या होता है? It will extend to all of the company's debts. Even if the assets are not sufficient, then the personal assets will be invited in order to pay off the debts of the company. Liability is not only, it is unlimited till the time the company is not owned up. Once the company has been winded up, then it is over. Members can be called only in the event of winding up. Again, company limited by guarantee and unlimited company, दोनों में ही at the time of winding up बुला सकते हो आप. ऊपर वाले दोनों की लाइबिलिटी मेमोरेंडम में मेंशन है, अनलिमिटेड की लाइबिलिटी आर्टिकल्स ऑफ एसोसिएशन में मेंशन है. as far as the concern is a going concern means your shares are only liability which can be enforced. So as far as the company is a going concern, इसका meaning ये है कि लाइफ टाइम ऑफ द कंपनी में सिर्फ आप शेयर होल्डर्स की अनपेड अमाउंट वाले लाइबिलिटी को ही इन्फोर्स कर सकते हो. Unlimited liability and guarantee वाली amount will arise only at the time of winding up of the company. And if the liability of the company is 1 lakh rupees and the shareholders have paid 50,000, they only have 50,000 rupees which has been paid, balance 50,000, how will they pay? Their personal assets will be sold off in order to pay off the balance 50,000. Is that clear? All right. Any doubt still here? Company limited by guarantee and shares. Then who is the memorandum of association? Oh my God, Mr. Motiani, memorandum of association means a document. It is a public document about which we will study in detail. It is the important document which tells all the information about the company, how it was incorporated, what is the name of the company, all the details are given in the M. Mohammed Farhan, Section 8 company, we are yet to do. Yes, Mr. Anuj Kumar, that's absolutely correct. Okay, Mr. Mohammed, I'm now getting your questions. Don't worry. Miss Madhu, what have you not understood? Please ask your question. Mr. Motiani, shareholders will pay the liability if the company is limited by shares. You have taken up the shares in the company. Whatever is the unpaid amount, that will be required to pay it. And after that, you will be paying up from the liability limited by guarantee. Thank you, Mr. Ranjit. He says, crystal clear, no doubts. Yes, tribunal is a kind of court, Miss Khushi. That is absolutely correct. Thank you, Tapaswani, Renuka, all of those who have written crystal clear. Ariharan, Articles of Association is again a document which we will discuss further in the chapter. In the third session, we will discuss in detail about what is MOA and what is AOA. As of now, बच्चा simply mention that in case of liability limited by shares and guarantee, कहाँ पे लिखी होती है liability? Memorandum में लिखी होती है. Unlimited companies की liability articles में लिखी होती है. बस इतना ही याद कर. Okay, Ms. Divya. Satyam Raj, owner of the company and the members are different. Owner of the company are the members. How the members? Okay, I will explain you how the. Yes, OPC is very interesting. Privileges means the benefits, Mr. Sheikh Bashir. Privileges का मतलब फायदा क्या है, benefit क्या है? तो guarantee company को privilege दिया गया है कि आपकी liability will arise only at the time of winding up. This is the benefit that has been given to the company limited by guarantee. मिस्टर अनुज कुमार, अनलिमिटेड कंपनी हिंदी में अगर आप समझना चाहते हैं तो जैसे आप सोल प्रोप्राइटर में सारी लाइबिलिटी आपकी होती है, तो कंपनी के एसेट्स हैं, आप 1 करोड़ के एसेट्स हैं और 1 करोड़ की लाइबिलिटी है, तो एसेट्स पे डिस्पोज ऑफ करके लाइबिलिटी पे हो. सपोज 1 करोड़ लाइबिलिटी है कंपनी की और सिर्फ 50 लाख के एसेट्स हैं, तो बाकी 50 लाख आप घर से लेकर आएंगे और कंपनी की लाइबिलिटी को पे करें. दिस इज द मीनिंग ऑफ अनलिमिटेड कंपनी. Yes, Anusa Singh, both of them are required to be paid at the time of winding up of the company. Sania Khan is asking, may only winding up shares? Yes, that's correct, Sania. During the company limited by shares, anytime during winding up and lifetime of the company. I hope it's clear now. Miss Anjali, separate legal concept will definitely be there. Yes, Renuka Gaurav, that is absolutely correct. It is definitely covered in some part of your business studies syllabus in class 12th also. Yes, Mr. Mayank, you can read MOA and EOA of any company. In fact, before making any investment in any company, these are very important documents which should be read before you invest in any company. Thank you, Mr. Surya. He's finding the chapter very interesting. Thank you, Mr. Anuj Kumar. Thank you, Sheikh, Sanya, everybody who is clear about their doubts. And there is a doubt on page number 6.4, which Divya has mentioned before. So let us go on point number 6.4. What do you want to ask over here? Quickly ask. Page number 6.5. Okay. Oh, so these are the same points that we just did, child. Separate legal entity concept. It means a person is different from its subscribers to the memorandum. So everybody listen carefully. Who are the subscribers to the memorandum? So I and me and Satyam Kumar and Ariharan, Yes, they're like a deed or document. So I have already taken name of Satyam. Sanya Khan and Ariharan and Harleen ma'am decided to form a company. So we said, let's open up a company. Let's make a good metallic body mobile phones and we'll be doing sale and purchase of mobile phones. Now me, Ariharan and किसका नाम लिया मैंने? Sanya. We have come up with an idea. अब ध्यान से सुनो, अभी छोड़ दो उसको, मत लिखो. It is a very important information that I'm sharing with all of you right now. So we have come up with an idea of sale and purchase of mobile phones. So who are we? We are promoters. We are going to promote our business, that this is the idea that we have in our mind and we want to open up a business related to this idea. Now, when I got this idea, I want to open up a company and I want to open up a company, then what will I do? I will get myself registered with the ROC. I will become a subscriber to the memorandum. How will I become subscribers to the memorandum? I will sign the MOA. बिकॉज जब भी आप कोई कंपनी खोलने जा रहे हैं तो सबसे पहले आप कंपनी का एक एमओए बनाते हैं एंड आप उसको रजिस्टर कराते हैं आरओसी के साथ, रजिस्ट्रेशन होती है कंपनी. सो नाउ व्हेन आई हैव मेड दिस एमओए, दिस मेमोरेंडम, वी ऑल हैव साइंड दिस मेमोरेंडम. So who are we? Now we have become subscribers to the memorandum. Earlier we were promoters. Now we have become subscribers to the memorandum. Once a company will get registered, section 9 में मैंने आपको सारा explain करना था ये वाला, but अब आप भी सुन लो story because you keep asking again and again who is a shareholder. So now when we get ourselves registered, we get that thappa of incorporation that the company has been incorporated. Then me, Sanya and Ariharan, we all will become the members of the company. Who will we become? We will become the members of the company. पहले हम क्या है, प्रमोटर है, फिर हम साइन करते हैं मेमोरेंडम को तो हम सब्सक्राइबर्स टू मेमोरेंडम बन जाते हैं. And when the company has been incorporated, we become the members of the company and then we take shares in the company. Then who do we become? You have to tell me. Once the members have taken up the shares in the company, they become the, आप बताओगे आपकी बारी. Excellent. They become the shareholders. They become the share. Thank you so much, Mohammed Farhan. I am also glad that I am able to teach all of you. And I also enjoy when you give me such beautiful answers. So excellent answers given by everyone. Yes, ma'am. Now we become the shareholders. So that is the difference between being a subscriber to the memorandum. तो subscriber कुछ नहीं है, subscriber to the memorandum members की ही बात कर रहा है, क्योंकि हम अभी कंपनी बनी नहीं है, इनकॉर्पोरेट नहीं हुई है, तब तक हम सब्सक्राइबर्स होते हैं एंड जब बाद में हम मेंबर्स बन जाते हैं फिर हम शेयर होल्डर्स. So Divya, it is simply trying to tell you that members are different, shareholders are different from the company that we have formed. Company has its own assets. Only the creditors can sue it. So means when the company is going into winding up, the debts of the company will have to pay its liabilities. How their liability is being paid off, that is what we have just understood. For liability by limited by shares, guarantee and unlimited company, all of them three have a different concept of paying off the liability. And this is the major line. What means by company is a separate legal entity. That means company now has, you have made a company has its own assets, company can own the property in its name. It is basically trying to protect you from the personal liability of the owners. When I was a sole proprietor, I am into sale purchase of this water bottle. Whatever liabilities for this water bottles I have incurred, I am liable. I have to pay everything. But once I formed a company, so this is the company that I formed. So this company body corporate is different. I am different. Now, whatever the liabilities for this water bottle is, the business, this company is liable for this. My personal liability will be only to my personal assets. Okay, that is the difference. Then we are not the owners of the company's assets. Companies are different. We are not the joint owners. Company has its own assets. That's why Makora could not get the insurance. Remember, because the timber was not insured in the name of the company. सो कंपनी एक बार क्रिएट होगी तो कंपनी पेपर्स पे क्रिएट हो जाती है, कंपनी अपने नाम पे बिजनेस कर रही है, कंपनी के नाम पे आप बिजनेस कर रहे हो, कंपनी प्रॉपर्टी होल्ड करेगी एंड कंपनी कॉन्ट्रैक्ट्स कर सकती है ऑन योर बिहाफ. सो कंपनी इज डिफरेंट, शेयर होल्डर्स आर डिफरेंट, इट इज होल्डिंग इट्स ओन प्रॉपर्टी इन इट्स ओन. Is that clear, students? Now let's quickly start with the concept of OPC. Now, what is an OPC? So from here only we can move ahead to OPC. OPC means, I just now explained you that company gets a separate legal entity. So OPC, this man earlier, what he was doing, he was a sole proprietor. So he wearing this specs and holding his suitcase and laptop in his hand. He was very happy doing the business all alone. But what happened, children? He was the only single man ओपनिंग अ सोल प्रोप्राइटर, मैंने अभी अभी आपको बताया इसकी लायबिलिटी अनलिमिटेड थी। तो गवर्नमेंट ने 2013 एक्ट जब आया, अमेंडमेंट्स आई कंपनीज एक्ट 2013 में, उन्होंने कहा लेट्स इंट्रोड्यूस अ न्यू क्लास ऑफ कंपनीज विच कैन बी रन बाय अ सिंगल पर्सन। क्यों ना हम ये सोल प्रोप्राइटर जो अपनी दुकान खोलकर बैठा है इसको बोले कि तू भी कंपनी बना ले। क्योंकि प्राइवेट कंपनी में तो मिनिमम 2 पीपल चाहिए होते हैं। पढ़ा हुआ है आपने बिजनेस स्टडीज में, अगर आप कॉमर्स बैकग्राउंड से हो, you know what is a public and private company, you have a fair idea. OPC is the only company where only a one person can also create a company. अब आप बोलोगे मैम सिंगल पर्सन था, सोल प्रोप्राइटर था, डिपार्टमेंटल स्टोर रन करो, मुझे क्या जरूरत पड़ी कंपनी बनाने की? क्योंकि मुझे सेपरेट लीगल एंटिटी का फायदा चाहिए, मुझे लिमिटेड लायबिलिटी चाहिए, इसलिए मुझे कंपनी बनानी। उसका आइडिया था एंटरप्रेन्योरशिप को इनकरेज करने के लिए। होता क्या था, लोग डरते थे कि हम बिजनेस करेंगे, रिस्क अंडरटेक करेंगे, सो हमारी लायबिलिटी इतनी ज्यादा अनलिमिटेड होती है बिजनेस करने। तो सोल प्रोप्राइटर्स भी एंटरप्रेन्योरशिप में नहीं जाना चाहते, सैलरी बेस्ड बिजनेस में जाना, कंपनी जॉब में जाना चाहते। सो उन्होंने कहा आप ओपीसी बनाइए, कंपनी बना लो ना, क्योंकि कंपनी की लायबिलिटी अलग है, शेयर होल्डर की अलग है, तभी तो वो कॉर्पोरेट वेल एग्जिस्ट कर रही है दोनों में। Okay, so one person was introduced to encourage entrepreneurship so that the people should come, and corporatization of business, so business will get the corporate legal existence. Otherwise you are doing a business as a name of sole proprietor, that time also you were doing a business, now you have corporatized your business, means you have obtained a legal structure, artificial company has come into existence. So OPC is different from sole proprietary concern. OPC has a separate legal entity and limited liability. Whereas the sole proprietor, his liability was unlimited. All of the owner's assets were whether official and personal. So ये जब अंकल सूटकेस लेकर जो जा रहे हैं, ये जब सोल प्रोप्राइटर थे, तो अगर इनकी 1 करोड़ लाइबिलिटी थी, 1 करोड़ इनको पे करनी पड़ती थी। तो अगर सिर्फ 50 लाख के एसेट्स थे, इनको 50 लाख अपने घर से एसेट्स बेचकर भी लाइबिलिटी फुलफिल करनी पड़ती थी। बट ओपीसी में क्या ऐसा करना पड़ेगा? नो, लिमिटेड लाइबिलिटी, लिमिटेड बाय शेयर्स, लिमिटेड बाय गारंटी, और इट कैन बी अनलिमिटेड। अभी आपने ऊपर पढ़ा लाइबिलिटी कैसे लिमिटेड होगी। Is that clear? So what is the benefit of having a OPC? One, we get a separate legal entity, and second, we get the limited liability. And also the procedural requirements are very, very simple. You get number of exemptions if you open OPC. Now, what is the meaning of these exemptions? Children generally feel, ma'am, what exemption? हमें तो पता ही नहीं exemption क्या होती है। क्योंकि जब हम सीए इंटरमीडिएट में जाएंगे तो हमें बताया जाएगा आपने एनुअल जनरल मीटिंग होल्ड करनी है, आपने डिविडेंड पे करना है, कंपनी के अकाउंट्स बनते हैं, कंपनी का ऑडिटर आता है। इन सब चीजों से ओपीसी को एग्जेम्पशन, क्या क्या एग्जेम्पशन हैं हम वहां पढ़ेंगे। अभी हमें सिर्फ इतना समझना है कि इट इज अ सिंपल प्रोसीजरल रिक्वायरमेंट्स। बहुत ज्यादा प्राइवेट एंड पब्लिक कंपनी में यू हैव अ डिटेल्ड प्रोसीजर्स दैट यू हैव टू फॉलो, कंप्लायंस करने पड़ते हैं। ओपीसी डज नॉट हैव टू अंडरगो सो मेनी कंप्लायंसेस. So quickly, let us brief up the first paragraph point. OPC, only a single person can open up a company. It's a new concept introduced by Companies Act 2013. Number two, it has come up to encourage the entrepreneurship. People should come forward, undertake a risk, and startups. Startups को promote करने के लिए OPC has come up. Only a single person can run a company. You don't need minimum 2 as you need for a private company. Only a single person running a company is known as the concept of OPC. What is the benefit of OPC? Benefit of OPC is you get a separate legal entity concept with the limited liability, and the procedural requirements are also very, very simple. You get number of exemptions when you're setting up of OPC. You don't need to have to comply with all the formalities. Is that clear? So OPC is a private limited company. अब सारे एक एक करके पॉइंट्स मेरे साथ मार्क करते जाना, ध्यान से सुनना, बहुत इंपॉर्टेंट कॉन्सेप्ट है। सुनोगे नहीं, अपने आप स्टडी में ढूंढ ढूंढ के डाउट्स भेजते रहोगे तो समझ नहीं आए। 100% attention here. I guarantee you, you will learn it right now with. So be attentive. OPC is a private limited company. So what do you mean by this? So Mr. A opened up an OPC. So A OPC private limited. Can Mr. A open up a public company which is an OPC? Answer is no. OPC is always a private limited company. OPC कभी भी public company नहीं हो सकती। क्या मतलब है इसका? इसका मतलब ये है कि क्या हम पब्लिक को कह सकते हैं ओपीसी में इन्वेस्ट करो? नहीं, बिकॉज वाई? बिकॉज ओपीसी इज ऑलवेज अ प्राइवेट लिमिटेड कंपनी. Can you convert OPC into later into public or private? Yes, you can do that, but that conversion is again part of your intermediate. It is not covered over here. एज ऑफ नाउ हमें क्या याद रखना है कि ओपीसी एक प्राइवेट लिमिटेड कंपनी। तो अगर मैं आपसे बोलूं कि ओपीसी पब्लिक कंपनी हो सकती है तो आपका आंसर होना चाहिए नो। कितनी मिनिमम पेड अप कैपिटल एज में बी प्रिस्क्राइब्ड, वो रूल्स में जब आएगी जितना बताएगा तो हम ले लेंगे, अभी रूल्स में कुछ भी लिमिट प्रिस्क्राइब नहीं। वो कहते हैं ओनली 1% एज अ मेंबर, मिनिमम पेड अप कैपिटल, नो लिमिट हैज बीन प्रिस्क्राइब्ड। So it says that the minimum paid up capital should be this much. How much? It has not yet been written. So जब रूल्स आएंगे, कंपनी अमेंडमेंट रूल्स, मैंने आपको लास्ट टाइम भी बताया था, रूल्स अमेंड होते रहते फ्रॉम टाइम टू टाइम. Whatever limit they have mentioned over there, that will become the minimum paid up share capital. As of now, there is no. This much is clear. Now let's move ahead. So we have understood OPC is a private limited company. Single person is the member. Minimum paid up capital should be there. No limit has been given as of now. Now these 3 points, these 4 points, इसके साइड पे लिख लेना. All these 4 points are related to the nominee of an OPC. All these 4 points are related to the nominee of OPC. Now, my question to all of you, have you ever heard that your parents have taken the FD in your name, or you have applied to the bank account for opening the FDs? तो कभी भी अगर आप एफडी या सेविंग अकाउंट कुछ भी ऐसा खुलवाने जाते हो, एफडी अकाउंट में इन्वेस्ट करते हो, तो वो आपको क्या बोलते हैं कि आप, बैंक क्या बोलते हैं कि आप नॉमिनी किसको बनाओ. तो नॉमिनी का मतलब क्या होता है कि कल को अगर आपने मिस्टर ए ने एफडी करवाई, सो इफ मिस्टर ए डाइड, ही इज नो लॉन्गर देयर, whatever amount he has invested in this FD will be given to his nominee. Is that clear? All of you know who is a nominee. So if you have opened up a bank account, you have taken a fixed deposit, FD has been opened up in your name, bank will always ask you, please create a nominee for yourself. That means tomorrow, if there is any uncertainty, if you have died, your entire amount invested along with the interest income will be given to your nominee. So this is the meaning of nominee. Similarly, in OPC, how many members are there in OPC? चलो देखें आप जाग रहे हो या नहीं. How many members are there in OPC? Yes, we will take a break. After OPC, we'll take a break. Don't worry. One person is the member in OPC. So now that only a single person is doing the business, I just explained you with so much of less efforts, procedural requirements, he has taken up the benefit of separate legal entity. Tomorrow there can be any uncertainty. The single person is the member. He's running such a big company. He can fall sick. He can die. So law has said that OPC should always have the name of nominee. So tomorrow, if this member has died or he become incapacity to contract, means he has gone mad or he has suffered from any disease, then that nominee will become the member of the company, because company to regularly chali rahi hai na. Company has got the separate legal existence. So where this name has to be written, you have to write in the memorandum of the company when we do the memorandum of association. Great. Somebody has written, ma'am, aaj break nahi chahiye, bahut maza aa raha hai. So good. You are enjoying the session. So that's great. So memorandum will always indicate the name of this nominee. So where do you have to write the name? In the last clause, we will have different clauses of memorandum: name clause, office clause, object clause. At the last, you have the this name for the nominees clause that you have to give, where you will give the name of this person, that in case this person who has formed the OPC, if he dies, then this person will become the member of the company. बस थर्ड पॉइंट इतनी सी बात बता रहा है कि एमओए आपका नाम देगा नॉमिनी का, जो बंदा आपकी जगह पे बिजनेस करेगा अगर आपकी डेथ हो जाए. Who is the other person whose name is given? Who is this other person? Means the nominee whose name has been given in the memorandum shall give his prior written consent, and the same has to be filed with ROC. Now, when you go to CA Enter, you will learn that there are different INC forms. So there is an INC 4 form in which you have to file at the time of incorporation, that this person who has, you don't have to learn INC 4 form right now, but I'm just telling you that all these procedural requirements you will learn when you go to CA Enter. As of now, you simply have to remember that this nominee who has agreed to be act as your nominee, his written consent will be taken, and that has to be filed with the ROC at the time of incorporation along with the memorandum and articles. So what will happen? Let's take a practical example to make the situation even more interesting for all of you. There was Mr. Ram who decided to form an OPC. So only one person can form an OPC? Yes, ma'am, Mr. Ram formed an OPC. Mr. Ram formed an OPC with the minimum paid up capital. No limit has been given, so it is okay. He opened up the OPC with 1 lakh rupees. Then Mr. Ram named Mr. Sham as his nominee in the memorandum. What will the third step of OPC? He will take his memorandum of Ram OPC Private Limited. He will name clause में उन end में लिख देगा नीचे that Mr. Sham is going to act as my nominee. Now, Mr. Sham will also give the written consent, and while Ram is filing his papers with the documents along with the MOA and AOA, he will also file the written consent given by Sham. He will also file the written consent given by Sham with ROC at the time of incorporating the company. Now, such other person may be given the right to withdraw his consent. We can ask Sham to withdraw his consent. अब शाम को लगा कि मुझे नहीं लग रहा राम के साथ मेरी अच्छी बनेगी, मुझे इसका नॉमिनी नहीं बना. शाम को कुछ भी डाउट आया, उसको मन में नहीं है, उसको लग रहा है कि मुझे और भी काम है, मुझे नहीं नॉमिनी बनना. तो कैन ही विड्रॉ हिज कंसेंट? यस मैम, ही कैन विड्रॉ हिज कंसेंट. So if he has withdrawn his consent, member of OPC may at any time change the name of such other person. कौन है such other person? बार बार नॉमिनी को कह रहे हैं. By giving him a notice and intimating the registrar. So या तो नॉमिनी खुद बोल सकता है कि मुझे नहीं बनना तुम्हारा, या फिर राम शाम को नोटिस दे सकता है कि अब मुझे आपको अपना नॉमिनी नहीं बनाना, मुझे किसी और को बनाना. So these both the points are related to withdrawal or change in the name. So whenever, suppose now Ram said that Sham, I don't want you to be the nominee. So he will give a notice to OPC that Sham is no longer the nominee, and he will tell the ROC, now Mr. Karan is the nominee of mine. So he should also give the name of another person who has chosen to be the nominee. And fifth point is simply telling you that Sham can withdraw his consent. He can tell you that I don't want to be the nominee in your company anymore. That is up to his choice. Now, any such change will not deem to be the alteration of memorandum. अब इतना कुछ ये लोग लिख देते हैं ना, सीए इंटर का टॉपिक है ये ऑल्टरेशन ऑफ मेमोरेंडम, तो आपको कैसे पता होगा? तो ब्रीफली समझो, सेक्शन 13 टॉक्स अबाउट दी ऑल्टरेशन. ऑल्टरेशन का मतलब मेमोरेंडम में चेंजेस लाना. सो जब मेमोरेंडम में चेंज होता है, मेमोरेंडम इज अ वेरी बिग डॉक्यूमेंट चिल्ड्रन. इट्स कंपनीज चार्टर, कंपनी का सारा करता धरता, भी कंपनी क्या काम करती है, कौन डायरेक्टर्स है, कौन शेयर होल्डर्स है, प्रोस्पेक्टस कैसे फाइल होगा, सब कुछ इन्फॉर्मेशन कंपनी की मेमोरेंडम में दिया होता है. इट्स इंपॉर्टेंट डॉक्यूमेंट ऑफ द कंपनी. अब अगर हमें कुछ चीजें कंपनी में बदलनी है तो हमें मेमोरेंडम को ऑल्टर करना पड़ता है. ऑल्टर मींस चेंजेस करने पड़ते हैं मेमोरेंडम में, जो कि आप इंटर में सीखोगे किस तरह से होता है. यहाँ पे वो सिंपल सी बात कह रहा है कि अगर ओपीसी की नॉमिनी चेंज हो रही है तो आपको मेमोरेंडम को ऑल्टर करने की जरूरत नहीं है. सिंपल. एक एमसीक्यू बन सकता है कि डू वी नीड टू ऑल्टर द मेमोरेंडम इफ वी आर चेंजिंग द नेम ऑफ ओपीसी? नो. Why? Because in alteration of memorandum, you need to pass a special resolution. Here, you don't need to pass any special resolution. You don't need 90% of majority of shareholders. There is a single person who is running the company. So logically, it is not required. This logic will again become more better when you go to proceed to the further classes. As of now, any change in the name of the person, no alteration in memorandum is required. Clear हो गई? ये first 5-6 points are entirely related to nominee. Number 1, Ram can open the OPC. Number 2, no limit on the capital. Number 3, Ram will name Sham as the nominee. Number 4, Sham will give his written consent. Number 4, Sham has given the written consent, which has to be filed with the ROC along with MOA and AOA. Number 5, Sham can withdraw his consent. Number 6, Ram can change Sham to Karan. If he wants to change this person, Sham, he can withdraw his consent and he can name another person by intimating the ROC. And number 6, changing the name from Sham to Karan does not require any alteration in memorandum. I hope Ram and Sham are clear to you now. The nominee picture is entirely clear. Let's proceed and understand who is going to act as a nominee. Who is a OPC and who can be my nominee? There is a condition which has been laid down. It has to be satisfied in order to a person to open up an OPC or to become a nominee. Number 1, he should be a natural person. Natural person means an individual like you and me. Number 2, he should be an Indian citizen. So can a foreign citizen open up an OPC? No, foreign citizen cannot open up an OPC. whether resident in India or not, but he should have stayed in India for a period of not less than 120 days. So he should have stayed in India equal to or more than 120 days. Number 4, immediately preceding financial year. So immediately preceding financial year will be 1st April 23 till 31st March 24 if he has stayed in India immediately preceding financial year. So for this immediately preceding financial year will be April 22 till March 23. So during this April preceding financial year, he should have stayed in India for more than or equal to 120 days. Then only he can open up an OPC and then only he can be considered as a nominee for the sole member of OPC. तो राम को भी 120 डेज वाली कंडीशन सेटिस्फाई करनी है, शाम को भी 120 डेज वाली कंडीशन सेटिस्फाई की होनी चाहिए. देन ओनली यू कैन बी अ नॉमिनी ऑफ द ओपीसी. सो फटाफट से 4 कंडीशंस दोबारा देख लेते हैं. नेचुरल पर्सन कैन बी अ मेंबर ऑफ ओपीसी, इंडियन सिटीजन होना चाहिए, 120 डेज इमीडिएटली प्रीसीडिंग फाइनेंशियल ईयर में अगर रहा है तभी वो ओपीसी खोल सकता है, तभी वो नॉमिनी बन सकता है. सो हियर कम्स द फर्स्ट एमसीक्यू फॉर ऑल ऑफ यू. Mr. A, US citizen, wants to open OPC in India. Can he do this? Yes or no? A US citizen wants to open up OPC in India. So, Mr. Satyam Raj, whenever you change the nominee, you simply have to file the document with the ROC. You have to intimate the ROC that this is the name of the new person. You have to send a notice to the company, and the ROC or copy, signed copy will be sent that now Sham is not my nominee. Mr. Karan is my nominee. Mohammed Farhan, it's not part of your foundation syllabus, so don't worry about alteration of memorandum. पूजा यादव, हिंदी में क्या एक्सप्लेन करना है बेटा? मैं हिंदी में ही सारा कुछ बता रही हूँ, आपको जो नहीं समझ आया आप पूछ सकते हो. अनुज कुमार ने लिखा है क्रिस्टल क्लियर, एकदम अच्छे से याद हो गया ओपीसी, वंडरफुल, वेरी नाइस. एलएलपी में मत जाओ, सिर्फ ओपीसी में रहो. यस मिस दिव्या, देन शाम विल बिकम द मेंबर. Satyam Kumar, nominee will become liable only when he becomes the member. Here we are just naming the nominee that tomorrow if that Ram dies, then Sham will become the member. No, ma'am, he cannot because he is the citizen of USA. Excellent. Applause for all of you. I'm so happy that all of you have written it correct answer. No. Somebody saying no, ma'am, because he did not stay in India for 120 days. Tambeshwari, this was not the answer that you have to give. Simply इसका answer है Indian citizen, जो हमने अभी पढ़ा. Indian citizen can only open up an OPC. So since he is not an Indian citizen, therefore Mr. A cannot open up an OPC. Now another question in front of you. Mr. A, an Indian citizen, stayed in India for 2 months in the previous financial year. Can he open an OPC? Jaldi batao. He stayed in India for 2 months and for the balance 10 months he was in abroad. Can he open up an OPC? Yes, no, and why? Good, Tapaswini, Sanya. Pranalika Yadav. Good. First time I've read your name. Bajrang. Great answers. We have new names today. Sana, Vipin. Very good, children. Excellent answers you're giving. Quickly give me the answer for this one. I know I have not given you a break. I'll just give you a break in between. Definitely, he cannot open up an OPC. Why? Because the condition of 120 days needs to be satisfied. So since he has stayed for less than 125 days, so he cannot open up an OPC in the year. Can Mr. B, who stayed in India for 118 days, be a nominee? Correct answer for the second one. Now I am giving you the third MCQ. Can Mr. B, who stayed in India for 118 days, be a nominee for AOPC Private Limited? Mr. B, who stayed in India for 118 days, can he be my nominee for AOPC Private Limited? Yes, ma'am or no, ma'am? जल्दी बताओ. कहाँ चले गए बीच में? आंसर्स नहीं आ रहे मुझे. सो बिल्कुल ठीक आंसर दिया है. सेकंड वाला नो इज द इनकरेक्ट आंसर. 120 days is compulsory, and the third is also no is the correct answer. Why? Because even for the nominee, 120 days condition needs to be satisfied, even if you want to be the nominee of the sole member of OPC. Is that clear? So children, please, whatever points I have written in front of you, just make short notes of that. So it's already 12:10. Let's take a small break over here and then we will proceed. We'll try to wind up the types of companies today as much as we can do. After that, we have 2 more lectures on companies. So don't worry, we'll be completing as well as enjoying this syllabus. Thank you. All right, welcome back, students. So let's proceed in the same topic. Let's start with the OPC where we have left. So now the last 2 points over here that were remaining to discuss in case of OPC. Can we have more than one OPC or can we be a member of more than one OPC? Yes or no? You have to tell me. So A has already opened up an OPC in India, in Delhi. He has opened up an office. Can he open up another OPC in Mumbai as well? Can you have more than one OPC? Yes or no? So this is how you have to study, children. Try to form the questions out of whatever is written in the text. So if we frame a question, we can simply understand that no, we cannot form any OPC more than one. सैलोमन वर्सेस सैलोमन कंपनी का केस लॉ एक बार पूरा हिंदी में बता दीजिए. Okay, Ritti Bharti, don't worry. In the end, just remind me. I will explain that case law in Hindi also. No, ma'am, we cannot open more than one OPC is the correct answer. And even you cannot be nominee. We don't need we cannot be a nominee in more than one OPC. Okay. Nishi Garg is asking, what is the meaning of this line? Liability of a member ceases when he ceases to be a member. Ceases means when you stop to be a member. So the moment you have left the company, you're no longer associated with the company. You're not a member of the company. Your liability will also come to an end. So when you cease to be a member, your liability also ceases, means comes to an end. All right, excellent. So very nice answers given by all of you. We cannot have more than one OPC or we cannot be more than nominee also in more than one OPC. So even Sham can be nominee in one OPC and Ram can only have one OPC. And can we have the minor as a OPC member or nominee? The answer is no. A minor can also not be a member, neither he can be a nominee. Such company cannot be converted into Section 8 companies. Now, Section 8 companies, in the third session, you will be learning about Section 8 companies because it again in itself is a very detailed topic. Section 8 companies try to tell you that the charitable kind of companies which have been opened up. So OPC cannot be a charitable kind of organization. It can only be into, because we have already mentioned that OPC is for encouraging entrepreneurship for new startups. Okay, so OPC cannot be converted and cannot be formed as Section 8 companies. Though it can become a public or private company. How will it become private? The moment Ram and Sham become partners, they decided to make two members in the company. One member, Ram, Sham is the nominee. So now Ram, Sham has decided to make a new company, a private company. So minimum 2 members and maximum 200 you can have in a private company. So if he wants to get it converted into public company, then Ram will need 6 more members because 7 minimum company members are required in order to form a public company. And the last one is OPC cannot carry out non-banking financial investment activities. So any investment in securities or in institutional non-banking institutions, OPC cannot have non-banking financial investment activities. You can only do into the business kind of activities, which we have decided in order to encourage entrepreneurship. So OPC cannot be into NBFCs. So NBFC खोल सकते हो आप OPC? नहीं, आप नहीं खोल सकते हो. So these are the benefits which we have discussed in the beginning also. So this beautiful flowchart has been given. These are the benefits which has been given to the OPC. So let's quickly move down to the private company. Private company is again having the minimum paid up capital. Have we prescribed? No, we have not prescribed. What are the restrictions that private company has? It restricts the right to transfer its shares. So the restrictions in public company, you can freely transfer your shares. Transferring your shares means you have taken up the shares, you can transfer to another member. But in a private company, there are certain restrictions. What are those restrictions? Again, CA interpart. हमने नहीं पढ़ना restrictions क्या है, हमने सिर्फ इतना याद रखना है private company की definition ही ये है कि it is a company which has minimum paid up capital given by its prescribed and by its articles. AOA में उसने restriction लगाई हुई है to transfer the shares and it must have minimum 2 and maximum 200 members. Except in case of OPC, क्योंकि OPC में तो one person is the only company. Other than OPC, all the private companies can have maximum 200 members and minimum 2 members. Where two or more person hold one or more shares joint. Now, this much is clear. Private companies definition is clear. Section 2, subsection 68. Now, what is given over here? Two or more person hold one or more shares in the company jointly. They will be treated as a single member. इसको important mark कर लेना और इसी के base पे case study based question भी आ जाता है. Now, Mr. A is holding two or more shares jointly. So if he is holding two shares jointly, that share will be counted as a one share. So if there are 10 members who are holding 10 shares jointly, then they will be counted as 5 members. Why? Because they are treated as a single member. Where two or more persons hold the shares jointly in a company, they will be treated as a single member. So there is a case study in which it was came in exam once that the 20 members were holding 20 shares jointly. So they were treated as total 10 members because one share held by one member will be considered as a single member. So where you're holding a jointly two shares by one person, so it will be considered as a one member. Therefore, maximum 200 limit can be met. So in case of meeting a limit of 200 members, you should consider the jointly shareholders to be a single member. And the person who are in the employment of the company shall not be considered. So if I tell you that the shareholders of the company are 500 shareholders in a private company, out of which 350 are in the employment of the company. There are 500 members of the company. 350 are the employees. So how many balance left? 150 are the members. So is it okay to have such private company? Are we crossing the limit of 200? You tell. कहते हैं 500 members है private company के जिसमें से 350 members are in the employment of the company. They are employee of the company. So how many are the members? 150 are the members. Yes, absolutely correct, Mohammed Farhan. Joint owners of share will be treated as one. So how will you count this? If 350 are the employees of the company, so 150 are the members. Are we crossing the limit of 200 members? Yes, ma'am, or no, ma'am? No, ma'am is the correct answer. No, ma'am is the correct answer. Why? Because 200 is the maximum limit that we have. We are only having 150 members. The 350 members will not be counted. Don't worry, Mohammed Anas Sarang. We will do the example of joint members also. As of now, just keep on noting down whatever information I'm giving you and telling you. So employee of the company will not be counted. Excellent. So we are within the limit of 150 members. So we are within the limit of 200 members. Even if the former employees of the company will not be counted in case of the total members of the company. So these are the 3 points that you have to remember. So out of 200 members limit that we are counting, number of members holding the shares jointly. So Mohammed Anas, if there are 20 shareholders who are holding 2 shares jointly each, so that means there will be total 10 shareholders. So if one shareholder is holding 2 shares, so there are 20 shares total, so there will be treated as 10 members. So suppose there are 150 and 350, I have told you the employment of the company. So they will not be counted in the members of the company. And we have 150 members of the company. So total 160 shareholders will be considered, which is within the limit of 200. Therefore, the private company is holding the valid limit of maximum 200 members. All right. Again, I have a very important case study based question in the next session for all of you. As of now, just learn all these points. Application of the example will be done in the next class. All right. So private company क्या-क्या हमें याद करना है? Minimum 2, maximum 200 members. Shares held jointly by a person will be considered as one member. Previous employment also not considered, and who are in the employment, they will not be considered as the members of the company. And it shall prohibit any invitation to the public. You tell me, children, can a private company issue a prospectus? Can we hold an IPO and invite the public to invest in our companies? The answer is no. Why? Because we're a private limited company. So we have been prohibited to invite the public. Only public can be invited if you are a public limited company. Private limited company cannot invite the invitations from the public company. तो आपने क्या याद करना है? आपने significant points study material नहीं, आपको summary बनाकर दे दी है. You don't have to apply much of brain. You simply have to remember all these points. No minimum capital, minimum 2, maximum 200, excluding the present employee and members and present employee cum members. Both are past employee cum members are also excluded. Right to shares are restricted. Prohibition on inviting to the public. Small company is always a private company and OPC is also a private company. अभी हम स्मॉल कंपनी के बारे में पढ़ने जा रहे हैं, तो कोई भी जो स्मॉल कंपनी है वो हमेशा ही प्राइवेट कंपनी होगी एंड ओपीसी विल आल्सो बी अ प्राइवेट कंपनी. So my important question to my audience out over there is, can you open an OPC as a public limited company? Yes, ma'am, or no, ma'am? Can you open an OPC as a public limited company? Conversion of OPC is not your part of syllabus, Mohammed Farhan, so don't worry. Sagufta, how the 10 will be counted when we do the case study based question, there you will understand. As of now, simply remember that joint shareholders will be treated as one. So you and me jointly holding a share, so we will be treated as one member. Very good. No, ma'am. OPC is always a private limited company. Why, Sakshi, you are saying yes? No is the correct answer. OPC can never be a public limited company because OPC is always a private limited company. Very good. Excellent answers have been given. So now let's proceed to small companies. Small companies, children, also like a private company. Small company की ना इतनी easy definition है. थोड़ी सी ट्विस्टेड एंड टर्न्स हैं, बट सिर्फ डेफिनेशन हमें लर्न करनी है. एग्जामिनर आपको स्ट्रेट अवे क्वेश्चन पूछ देता है डिफाइन स्मॉल कंपनी. 2 मार्क्स का भी आया हुआ है, 4 मार्क्स का भी आया. एज इट इज डेफिनेशन लर्न करनी है. हाँ जी मैम, एज इट इज करनी है. यू हैव सैटरडे संडे. आई विल बी मीटिंग यू ऑन ट्यूसडे. सो टुडे यू विल मेक योर नोट्स अबाउट ऑल द टाइप्स ऑफ कंपनीज. Tomorrow you will sit and learn each and every type of company by heart. And on Tuesday, when I meet you, you have 2.5 days in between. All the types of companies should be learned nicely. Small company is a company other than public company, मतलब कि वो प्राइवेट कंपनी है. तो पब्लिक नहीं है तो प्राइवेट है. तो हम पहले ही पढ़ चुके हैं कि स्मॉल कंपनी इज अ प्राइवेट कंपनी. इररेलेवेंट इन्फॉर्मेशन, मतलब रेलेवेंट है, मतलब कुछ समझने वाला नहीं. सो स्मॉल कंपनी इज अ प्राइवेट कंपनी. पेड अप शेयर कैपिटल एंड टर्नओवर की लिमिट दी हुई है स्मॉल कंपनी को डिफाइन करने. So how much is the paid up share capital? It says it shall not exceed 50 lakh rupees. अब ध्यान से सुनना. It shall not exceed 50 lakh rupees or such higher amount as may be prescribed, which shall not be more than 10 crore rupees. Which shall not be more than, दूसरा पेन यूज करेंगे इसमें, which shall not be more than 10 crore rupees and turnover shall not be more than 100 crore. अभी भी स्टडी पुराना ही प्रोविजन दे दिया. ये 40 and 4 crore and 40 crore हो चुका हुआ है. पहले नीचे अमेंडमेंट देख लो इसकी. So please, this is a very important amendment, children. It says for the purpose of subclause 1 and subclause 2, जो ऊपर दिए गए subclause 1 and subclause 2 of section 2 subsection 85, the limits of paid up capital and turnover shall be read as 4 crores and 40 crores. Now, what my children have to do over here is, you don't have to read that provision. You simply cut down this 10 crores and write over here 4 crores. Cut down this 100 crores and write down 40 crores. Now, this is the upper limit that the law has given. It says the paid up capital should be less than 50 lakhs. If you want to be a small company, your paid up capital should be less than 50 lakhs. And if your turnover is less than 2 crores, if it is less than 2 crores, sorry, we'll be using this sign. It should not exceed 50 lakhs. So 50 lakhs is the maximum limit and 2 crore and is very important. And 2 crore is the limit for the turnover. Then you are a small company or such higher amount. Now law has said ये amount 50 lakhs की बढ़ाई भी जा सकती है. कहां तक बढ़ाई जा सकती है? 4 crore तक and 40 crore तक. So what do we have to learn, ma'am? If your paid up capital is less than 4 crores, up till 4 crores or less than 4 crores, and your turnover is up till 40 crores and less than 40 crores, then you're a small company. 50 lakhs is the limit that they have given as of now. Maximum it can be taken to 4 crores. So how do we have to write in the exam? Small company is a private company. Number one, its paid up capital should not be more than 50 lakhs or such higher amount as may be prescribed, which shall not be more than 4 crore. तो वो अपर लिमिट कहां तक जा सकती है वो भी गवर्नमेंट ने दे दी आपको कि 4 करोड़ तक लिमिट सेट हो सकती है. अभी तक हम जो पढ़ रहे थे मिनिमम लिमिट प्रिस्क्राइब बट नो लिमिट हैज बीन प्रिस्क्राइब्ड हियर द लिमिट हैज बीन गिवन. So 50 lakhs or such higher amount, that is maximum 4 crore. Turnover as per the profit and loss account of the immediately preceding financial year, less than 2 crore rupees or such higher amount, maximum 40 crore. So that is the definition of small company. So if I ask you the paid up capital is 3 crores and the turnover is 30 crores, am I a small company? If my paid up share capital is 3 crores and my turnover is 30 crore, am I a small company? Yes, ma'am, or no, ma'am? जल्दी बताओ. Prince Kumar is asking how OPC is private company. So, beta, OPC is a single person who has formed a company. So, law has said that OPC can always be a private limited company. In a public company, you are inviting the shares from the public to subscribe. So, it is a close-knit company. Status of OPC as a private limited company has been given by Companies Act 2013. It is not that you and me have decided that we have to make it private company. It is law that has taken a decision that OPC can always be formed as private company. Now, what is private company? Whatever the provisions are applicable to private company will be applicable to OPC. Public company has huge compliances and huge procedural requirements to be done. OPC has been set free from that. That is why they have given the liberty to form it as a private company. Mr. Motiani, this is what is the difference between private company and OPC that I just spoke right now. आपने yes ma'am किसका आंसर दिया मैं ही भूल गई. अच्छा ठीक है, yes, it is a small company if the limit of paid up share capital is less than 4 crores and turnover is less than 40 crores, then yes is the correct answer. Yes, it's a small company. Very good. Let's proceed ahead. So the exceptions are small company cannot be a holding and subsidiary company. तो subsidiary and holding company को small company वाला clause नहीं applicable होता है. सेक्शन 8 को ओपीसी भी एप्लीकेबल नहीं था. सेक्शन 8 को हमने अभी ऊपर पढ़ा. सेक्शन 8 को स्मॉल कंपनी भी एप्लीकेबल नहीं. सो सेक्शन 8 कंपनीज आर चैरिटेबल ऑर्गेनाइजेशंस. दे कैन नॉट बी स्मॉल कंपनी. दे कैन नॉट बी ओपीसी. And any body corporate governed by special act. So ICAI is formed by an ICAI act. So statutory bodies which are formed by special act, they can also never be considered as a small companies. All right. So what are the significant points that we have to learn? It's a private company, paid up capital 50 lakhs. And what is the maximum limit up till which it can go? 4 crores. Turnover not more than 2 crores and the maximum limit is 40 crores. It is not applicable to Section 8 and holding and subsidiary company. Is that clear? Now, what is public company? We have done private company. प्राइवेट कंपनी में रिस्ट्रिक्शन थी ऑन ट्रांसफर ऑफ शेयर्स. यस मैम रिस्ट्रिक्शन थी. तो पब्लिक कंपनी में रिस्ट्रिक्शंस नहीं है. यू कैन फ्रीली ट्रांसफर योर शेयर्स. Public company, number one, it is not a private company. Look at the definition. So what is public company? Company which is not a private company. So that means we have invited public at large to invest in a company. Articles do not have the restricting clause. Shares are freely transferable. If you have purchased the shares of a public company, you can freely transferable to another person also. There is no limit of paid up capital, minimum 7 members. No limit on the maximum number of members. If I have opened up a Harleen Kaur Limited company, it's a public company, I can have as many number of members, infinite maximum number of members. And how many minimum number of members are required? 7. So if Harleen ma'am wants to open up a company with Mr. A and B, and we have 5 members total, A, B, C, D, and Harleen ma'am. A, B, C, and D, and E. Can we open up a public company? Yes, ma'am, or no, ma'am? A, B, C, and D, and E are the 5 members who want to open up a public company. Can we open up a public company? Yes, ma'am, or no, ma'am? Miss Sana Jamdar, we have still not done holding and subsidiary. Why are you asking doubts in that? We are yet to do it, beta. Yes, Mr. Nikhil, OPC can be converted into private and public company, but you cannot open up an OPC as a public company. So you will get the answer right now when I'm asking you A, B, C, D, and E are the 5 members. Can we open up a public company? Excellent answer given by Mr. Sheikh Bashir, Akash, Dheeraj, Anjali, Ranjit, Pooja, all of you. That no, ma'am, we cannot open because minimum 7 members are required in order to open up a public company. Similarly, Nikhil, the answer to your question, OPC, you have only 1%. In order to open up a public company, you need minimum 7 members. Then you can convert yourself into public company, but you cannot open a single person as a public company as OPC. Okay? Yes, Anuj Kumar, good. क्योंकि 7 members चाहिए. समझ आ गया. अब एक इंपॉर्टेंट पॉइंट है, सब्सिडरी ऑफ अ पब्लिक कंपनी इज डीम्ड टू बी अ पब्लिक कंपनी. सपोज एक पब्लिक कंपनी है एबीसी लिमिटेड. It has a subsidiary. All those who don't know the meaning of subsidiary company, let me first do the holding and subsidiary, फिर वापस आते हैं इसमें. इस पॉइंट को पहले होल्डिंग एंड सब्सिडरी समझकर फिर आते हैं. On the basis of control, we have 2 types of company, holding and subsidiary company. So holding का मतलब है कि मैं उस कंपनी को होल्ड कर, जब मैं किसी कंपनी के शेयर होल्डिंग होल्ड करती हूँ या फिर वोटिंग पावर है या बोर्ड ऑफ डायरेक्टर्स को कंट्रोल करती हूँ, तो वो मेरी कंपनी सब्सिडरी बन जाती. A company is a holding company in which to such companies are subsidiary companies. Let us understand the definition of subsidiary company. Subsidiary company means a company in which the holding company controls the composition of board of directors or more than 1/2 of the voting power together or along with its subsidiaries is being owned by a holding company. So let us take a very interesting example. ABC Private Limited is holding more than half of the voting power or more than 50% of the share capital of CD Private Limited. So जब ABC Limited is holding more than 50% of the shareholding or it is controlling the composition of board of directors, कंट्रोलिंग द कॉम्पोजिशन ऑफ बोर्ड ऑफ डायरेक्टर्स का मतलब होता है कि एबीसी लिमिटेड डिसीजन ले रही है अबाउट हाउ द डायरेक्टर्स विल बी अपॉइंटेड, हाउ द डायरेक्टर्स विल बी रिमूव्ड, हाउ द फंक्शनिंग ऑफ द बोर्ड ऑफ डायरेक्टर्स विल हैपन. ऑल दैट कंट्रोल इज इन द हैंड ऑफ एबीसी लिमिटेड. In such a case, ABC Limited will become the holding company and CD Private Limited will become the subsidiary company. Is that clear? So what is the meaning of holding and subsidiary company? If any company is controlling the board of directors of another company or it is controlling more than 1/2 of the total shares of another company, then it becomes the holding and subsidiary company. So here I have given you the definition: controlling composition of board of directors of more than half of the total power. So for example, these are the major subsidiaries: International Acquisition, Tata Steel Europe, Tata Thailand. All these are the subsidiaries of the Tata company. So subsidiary kaise banti hai? When you are having more than 50% of the shareholding. Let us see the examples from the study itself. So if I ask you children, A will be a subsidiary of B. Say for example, if B is controlling the board of directors of A, क्या कह रहा है वो? There is a company B company. It controls the board of directors. Controlling the board of directors means however the appointment and removal of directors have to be done, that is in the hand of B company. So if B company is controlling the board of directors of A company, then which is the holding company and which is the subsidiary company? Tell me. If B company is controlling holding means a special person. Anil Yadav, what are you writing? Child companies is correct. Children, don't give me vague answers. Please tell me what I've asked you. पता नहीं क्या ही लिखते जा रहे हो. 51% shareholding, Tameshwari, that is correct. More than 50% of the shareholding. So any 50.5% will also be considered as holding company. So if I have asked you, B company is controlling the board of directors of A company, then which is holding and which is subsidiary? Excellent. Akusa Petkar, Mr. Akusa Petkar, Satyam, Prince, Nambeshwari, Sheikh Bashir, all of you are correct. B is a holding company and A is the subsidiary company. Excellent. If A will be a subsidiary of B, if B holds, now second example is B is holding board of directors, then yes, ma'am, B is a holding company. If I ask you, okay, I will change the example. If C company is holding more than 50% of the share capital of B company, listen carefully. If C company is holding more than 50% of the share capital of B company, then which is the holding company, which is the subsidiary company? जल्दी बताओ. If C is holding more than 50% of the share capital of B company, then what is holding and which is subsidiary? C is a holding company and B is a subsidiary company. Excellent. Now, if B company is further holding A company, if B company is further holding board of directors of A company, then B and A both will become subsidiaries of C company. Is that correct? Let us see the further example that is given beautifully in the study material. It talks about the layers of subsidiary. So if B is controlling more than 50%, then A is subsidiary. If B is subsidiary of A and C is subsidiary of B, then C will become the subsidiary of A and B both. So if D is subsidiary of C, then they will become further subsidiary. कैसे होगा? A is holding B, B is further holding C. So therefore, A will also be the subsidiary of, C will also be the subsidiary of A. And if C is further holding D, then will D be the subsidiary of A as well? Yes, ma'am, D will also become the subsidiary of B as well as A. So this is how the layer of subsidiaries is created. Now, this is the point which I was trying to explain you in the public company case. It has again given the same point over here. Status of private company, which is subsidiary to public company. Now, first you all answer me. Can we say that ABC Limited is a public company? I'm not using the word private. That means it's a limited company. It is holding AB Private Limited Company. So that means if ABC Limited is holding more than 50% of the share capital of AB Choco Private Limited that we created, so that means AB Private Limited will be the subsidiary of ABC Limited. यहाँ तक सबको समझ आया? If AB Limited holds than 50% of the share capital of AB Private Limited, then which is the holding, which is the subsidiary? Write it with your own hands. लिख कर बताओ मुझे जल्दी. ABC Limited is holding more than 50% of the share capital of AB Private Limited. Then which is the holding company? Which is the subsidiary company? Yes, Sukanya, you're right. Therefore, ABC Limited is the holding company. AB Private Limited is the subsidiary company. Now, it says that private company. Now, this is a private company which has become the subsidiary of public company. Now, private company, when it becomes the subsidiary of public company, it shall deemed to be a public company, even if it is a private company. Deemed का मतलब होता है मान लिया जाएगा. ऐसा मान लिया जाएगा कि AB Private Limited is also a public company. ऐसा मैं नहीं कह रही हूँ, ऐसा सेक्शन 2 सबसेक्शन 71 ऑफ कंपनीज एक्ट कह रहा है. ये मत पूछना मैम ऐसा क्यों मान लिया जा रहा है, क्योंकि एक्ट में लिखा है क्योंकि पब्लिक कंपनी का 50% इन्वेस्टमेंट प्राइवेट कंपनी में आ गया, तो इस कंपनी को, प्राइवेट कंपनी को भी पब्लिक कंपनी मान लिया जाएगा, जस्ट फॉर द पर्पस ऑफ दिस एक्ट, इवन ऑल्दो इट विल कंटिन्यू टू बी अ प्राइवेट कंपनी इन इट्स आर्टिकल्स. इतनी ही इंफॉर्मेशन यहाँ पे याद रखनी है. इसके बियॉन्ड इंफॉर्मेशन सीए इंटर में पेपर में क्वेश्चन भी पूछता है. आपसे जो पूछेगा यही पूछेगा, व्हाट इज द स्टेटस ऑफ प्राइवेट कंपनी व्हिच इज अ सब्सिडियरी टू पब्लिक कंपनी. सो मैम, इफ यू आर अ प्राइवेट कंपनी एंड यू आर सब्सिडियरी ऑफ पब्लिक कंपनी, देन यू शैल डीम टू बी अ पब्लिक कंपनी. दैट्स इट. ऑल्दो इवन इफ यू कंटिन्यू टू बी द प्राइवेट कंपनी इन इट्स आर्टिकल्स. बस ये 2 लाइनें एज इट इज लर्न करनी कि अपने आर्टिकल्स ऑफ एसोसिएशन में तो प्राइवेट कंपनी की तरह ही अपनी प्रिविलेजेस क्लेम करते जाओगे. जो भी आपको प्रिविलेजेस दी गई हैं एज अ प्राइवेट कंपनी, वो मिनिमम 2 एंड मैक्सिमम 200 मेंबर्स वाला, बट आपको पब्लिक के लिए पब्लिक कंपनी मान लिया जाएगा क्योंकि आपके होल्डिंग जो है ना, 50% ऑफ द शेयर होल्डिंग आपकी पब्लिक लिमिटेड कंपनी के पास है. इस करके प्राइवेट कंपनी को पब्लिक कंपनी का स्टेटस मिल जाता है. इज दैट क्लियर? लेट्स डू वन मोर टाइप ऑफ कंपनी एंड देन वील एंड. So many types of companies. Can you imagine? That's why उन्होंने बोला कि अगर हम सीधा ही इंटर में शुरू करेंगे ना कंपनीज ऐप, तो बच्चे सोचेंगे ये पता नहीं इतना कुछ क्या है. तो उन्होंने फाउंडेशन में आपको टाइप्स ऑफ कंपनीज, मेमोरेंडम, आर्टिकल सब बेसिक बेसिक बता दिया, ताकि बाय द टाइम यू प्रोसीड टुवर्ड्स योर सीए इंटर यू वेरी वेल हैव नॉलेज अबाउट व्हाट इज कंपनी. नाउ लेट्स मूव टू द लास्ट टाइप ऑफ कंपनी फॉर द डे टुडे, एसोसिएट कंपनी. अब जैसे होल्डिंग एंड सब्सिडरी में 50% शेयर होल्डिंग का रिलेशनशिप था, एसोसिएट कंपनी में सिग्निफिकेंट इन्फ्लुएंस का रिलेशनशिप. वहां पे हम बोर्ड ऑफ डायरेक्टर्स कंट्रोल कर रहे थे, वहां पे हम 50% शेयर होल्डिंग कर, यहाँ पे हम सिग्निफिकेंट इन्फ्लुएंस एक्सरसाइज कर. What is the meaning of significant influence? Any company having a significant influence in another company, then they are considered as associate company. For meaning of significant influence means at least 20% of the voting power if you're holding in another company, or you are participating and controlling in the business decisions of a company, then both of you become the associate company. क्या बोला मैंने? If ABC Limited is having 20% of the voting power in PQ Limited, then ABC Limited and PQ Limited will be the associate companies. Or ABC Limited is participating in the business decisions of PQ Limited, then also they become associate company. And the third point is a joint venture will also be considered as the associate companies, where you have made a joint arrangements, you're having a joint control over the net assets of the management of the company, then also joint venture is also considered to be the associate companies. ABC and PQ have entered into a joint venture to have a common assets of the management of the company, then also both of them will be considered as the associate company. तो फटाफट से रिवाइज कर लो 3 पॉइंट. सिग्निफिकेंट इन्फ्लुएंस होना चाहिए एसोसिएट कंपनी में. सिग्निफिकेंट इन्फ्लुएंस का मतलब होता है 20% शेयर होल्डिंग, और यू आर हैविंग पार्टिसिपेटिंग इन द बिजनेस डिसीजंस ऑफ द कंपनी, और यू आर अ जॉइंट वेंचर, देन आल्सो यू आर एसोसिएट कंपनीज. क्लियर हो गया? फिर जुडिशरी वाला पॉइंट ही हटा दिया इन्होंने. Okay, they have removed that point. The judiciary relationship is not considered associate company, so that's good if you don't have that point. So let us quickly read the listed and unlisted companies also. What is a listed company? Scan Steel Rods is a public company whose shares are listed on the stock exchange Kolkata. So if your shares are listed on the stock exchange, then you are known as listed company. Why? Because you have signed a listing agreement for trading the shares in the capital market. So any public company whose securities are listed on the recognized stock exchange. What is the recognized stock exchange? आपने ट्रेडिंग सुना हुआ है, शेयर्स ट्रेडिंग होती है. पापा या ब्रदर से या सिस्टर से या मम्मा से पूछना कि आप शेयर्स में इन्वेस्ट करते हो, तो वो आपको बताएंगे रिकॉग्नाइज्ड स्टॉक एक्सचेंज पे शेयर्स लिस्टेड होते हैं. हम म्यूचुअल फंड्स में या शेयर्स में इन्वेस्ट करते हैं, तो हम शेयर्स का सेल परचेज करते हैं स्टॉक एक्सचेंज. तो ऐसी कंपनीज जिनके शेयर स्टॉक एक्सचेंज पे, आप खुद भी करते होगे ट्रेडिंग, नाउ इज इट इज सच अ कॉमन वर्ड. So the companies whose securities are listed in consultation with Securities and Contract Regulation Board, SEBI consider होता है इसमें. So they are considered as listed companies. However, the companies who intend to list the securities, suppose अभी पेटीएम सोच रहा है कि मैं लिस्ट हूं या ना हूं, तब उसे लिस्टेड कंपनी नहीं माना जाएगा. बट वंस यू हैव लिस्टेड योर शेयर्स, देन ओनली यू आर कंसिडर्ड एज अ लिस्टेड कंपनी. सपोज देयर इज अ कंपनी नाइका which is still thinking, although Nika has got with an IPO, I think so, but still if Nika is still in the listing requirement, if it's still thinking of listing its securities, then it will not be considered as a listed company. Word securities has been defined in the Security Contract Regulation Act. You don't need to open that act and learn the definition, but you should know that it is defined over there. Because listed company की 2 marks की definition आ जाए, then I expect all of you to write this and give a small example. And why it is called listed? Because we are signing a listed agreement, but for trading the shares at the capital market. And what is unlisted companies? A company whose shares are not listed. So आपने और मैंने कंपनी खोली, हमारे स्टॉक एक्सचेंज पे शेयर्स लिस्टेड नहीं है, तो हम लोग अनलिस्टेड कंपनी है. So let's have a quick revision. Private company, maximum 2 members, all is included in the definition of private company. Can you tell me? Do you remember? So any employee of the company, present, past employee of the company, shareholders holding jointly the shares will be treated as one members. That is what you have to be considerate in counting the members of the company. So what is the maximum number of members under a private company? 50, 150, 200, or there is no limit? Satyam Kumar, answer these MCQs now. Good. All of you have good knowledge about. Pavan says, मैं खुद भी invest करता हूँ. Madhu is also saying the same. So great, you know about listed and unlisted companies. हाँ जी, रीति भारती, सैलोमन का केस अभी हम समझा देते हैं. Thank you, Renuka. I'm glad you liked the lecture. Don't worry, Pavan. Half the lectures, so half the sessions have also been done, na? Mohammed Farhan is saying, don't end the lecture because we're really enjoying, but we have to end it, right? Okay, 200 is the correct answer. Sheikh Bashir, why are you giving 50? That is incorrect answer. Maximum number of members. I have been shouting at the top of my voice since the beginning. 200 was the correct answer in the previous one. So maximum number of members in a private company can be 200. So 200 is the correct answer. So 4C is the correct answer. All of you have given the correct answer. So, Mr. Nanda, if the company limited by guarantee, once you have asked the members to pay the amount which they have guaranteed to pay, then balance amount will be paid disposing of the company's assets, because company's liabilities are different, shareholders' liabilities are different. That is why it is a limited company. All right. All of you have given the correct answer. Yes, Tameshwari, that is a correct understanding about associate company. Let us do one more case study, one more MCQ. Minimum number of members in case of private and public company are, please tell the correct answer for this one, 3 and 7, 2 and 7, 2 and 9, none of the above. Meanwhile, okay, don't worry. Meanwhile, Riti has asked about Salomon versus Salomon. So in Salomon case law, child, what happened was that Salomon formed a company with his own family members. And when that company went into liquidation means जब company बंद हो रही थी, wind up हो रही थी, तो हमें creditors को पैसा देना था. So जब company के assets suppose 6,000 pounds asset बचे थे and Salomon एक secured creditor भी था, उसने debentures लिए हुए थे company के security देकर. So he was a secured creditor and there were unsecured creditors also. So there were unsecured creditors को कुछ नहीं मिला था क्योंकि कंपनी के एसेट्स ही 6,000 के थे एंड अनसिक्योर्ड क्रेडिटर्स 7,000 के थे. तो उन्होंने सारा का सारा पैसा जो था एसेट्स का जो बचा था वो सैलोमैन को दे दिया और अनसिक्योर्ड क्रेडिटर्स को कुछ नहीं मिला. क्यों? क्योंकि अकाउंट्स में जब आप पढ़ोगे whenever the company goes into liquidation, whatever assets are left, first payment is made to the secured creditors because they have provided security, and then the balance is given to the unsecured creditors. So people started fighting and shouting that Salomon was the owner of the company. Why he is keeping the money to himself? He should have given the money to the outsiders. So at that time, Supreme Court passed a judgment saying that Salomon is different and the company separate legal entity, corporate veil exists between the shareholders and the company. Salomon got the money because he was the secured creditor of the company. It has nothing to do that he himself is the owner. You yourself, owner, can also be the secured creditor of the company. So that is why the separate legal entity was given birth to. That is the major case law which explains the concept that company is different from its shareholders. Is that correct? Thank you so much, Miss Archie Goel. Sandhya Kumari, don't worry about how to write the law answers. Yes, Mr. Nanda, maybe I can try doing that as well. But don't worry, and we will try learning how to write the case laws answers in the next sessions as well, okay? And B is the correct answer. All of you have given the correct answer for this one. All right, 2 and 7 is the correct answer for this question. Let's do the last MCQ and then we'll just wind up because it's already the time. Significant influence means how much percentage of total share capital and business decisions under an agreement. So in order to be an associate company, we just discussed that there should be a significant influence. Yes, thank you, Mr. Tejban. Thank you so much, all of you students. Your wonderful comments make my day also more beautiful. And I really wish that you keep studying the way you have been doing till now. And what is the correct answer for this one? 6. D is the correct answer. Great. All of you have given the correct answer. So significant influence means 20% of the shareholding has to be seen in order to be an associate company, whether you're participating in the business or holding the voting rights. So 20% is the major shareholding that needs to be seen. All right. Mr. Omkar, tell us about the answer sections. No, you're not compulsory to learn the sections and case laws. You can avoid as far as your CA foundation is concerned. For inter, it becomes compulsory. All right, students, thank you so much. Please revise the types of companies. As I've told you, make short notes today and learn them over the period of 2 days. On Tuesday, I'm going to take a short test of your types of companies. You'll have to type and write it quickly. And after that, we'll be completing registration section 9 as well as the balance chapter along with your case study writing of the answers from the descriptive questions. Till then, thank you so much. Enjoy your weekend with your books. Enjoy your studies. Goodbye.